This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we speak about why failure to complete reconstruction in a timely fashion can defeat the right of an insured to receive the difference between actual cash value and full replacement value, and why in Iowa, when claims are fairly debatable, there can be no cause of action for the tort of bad faith. The homeowners, the plaintiffs, appealed from the district court's denial of their breach of contract, consequential damages, and bad faith claims in a case entitled Donnie Paul Bradley and Melanie Yvonne Bradley versus Allstate Insurance Company, a decision of the Court of Appeals of Iowa on January 23, 2025, that resolved the dispute. Donnie and Melanie appealed from the district court's summary judgment finding and final judgment following a contractual dispute against Allstate Insurance Company. The Bradleys alleged errors in the district court's interpretation of the insurance policy for their breach of contract claim and the granting of summary judgment to Allstate on their consequential damages and bad faith claims. The dispute arose as a result of 1. The Bradleys having purchased an Allstate insurance policy in 2024 for their Cedar Rapids home. 2. The policy included actual cash value and replacement cost value, ACV and RCV. 3. The August 2020 derecho windstorm caused significant damage to their home. 4. The Bradleys reported the damage and Allstate acknowledged the losses were covered under the policy. 5. The Bradleys, unhappy with Allstate, demanded appraisal in November of 2020, and the parties 6 signed an appraisal for the actual cash value in September of 2021, and Allstate paid the Bradleys in accordance with the insurance policy. Next, the Bradleys claimed breach of contract for Allstate denying RCV coverage, alleged bad faith, and demanded consequential and punitive damages, and the Bradleys admitted that they spent more on repairs than Allstate paid out, and they continued with the litigation. 9. The Bradleys ultimately paid for the repairs by financing their home to establish a home equity line of credit and taking out a loan against a retirement account. And 10. Allstate was to reimburse the Bradleys for repair costs in excess of ACV, the equivalent of the RCV finding, if repairs were completed within 180 days of the ACV payment. The district court granted summary judgment to Allstate on the consequential damages and bad faith claims because the repairs were not completed within 180 days, but denied it for the breach of contract claim. The Bradleys withdrew their request for a jury trial, and Allstate eventually paid the RCV finding of the appraisal. The Court of Appeals upheld the district court's decision that consequential damages were not available under Iowa law, and that the Court of Appeals agreed with the district court that the bad faith claim was fairly debatable and that the Bradleys did not set forth a valid bad faith claim. The question of whether the Bradleys were entitled to RCV payments was found to be fairly debatable as a matter of law. The court concluded that the undisputed facts established that there was no unreasonable delay in the ACV payment. Allstate reasonably disputed coverage as to the RCV payments on the basis that the explicit terms of the policy required repair to be completed within 180 days for an RCV payment to be made. The claim was, in the opinion of the Court of Appeals, fairly debatable because replacement was not completed with 180 days of the ACV payment. The Court of Appeals concluded that the Bradleys could not succeed on their bad faith claim, even though Allstate paid the difference between ACV and RCV rather than go through with a litigation. In my opinion, the Iowa Court of Appeals educated the Bradleys and their counsel, holding that an insurance policy is a contract with conditions. Allstate's policy provided as a condition that to receive the difference between ACV payment and the RCV payments, the repairs must be completed within 180 days of the ACV payment. Although there was a dispute over when the repairs were completed, Allstate paid both the AC and RCV payments, making the entire claim moot and the other claim damages for bad faith fairly debatable, since the Bradleys built something different than what they had before the damage and had to borrow money from a bank to do so. This video was adapted from my blog, Zelma on Insurance, and is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog and you'll receive notice of every blog posting, usually 5 or 6 a week, and you will gain access to the more than 4,950 blog postings. Please tell your friends and colleagues about this blog and these videos so that they too can subscribe. They're free. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider, for a very small fee, subscribing to my Substack publication. Thank you for your attention.